hours.
Reintroduce yourself,
Yeah.
please.
I think you can get your hours from Mr.
Do we get hours for this too?
It depends. This is the short version of the presentation, so you may not qualify for the full panoply of hours, but we'll try. Before I begin, I'm Sam Goren, your General Counsel from Goren Sheriff Beauty in Israel, and thank you for the opportunity. Just one caveat. In the audience today, we have elected officials and appointed officials. And I know that there are distinctions between the two of you in some respects when you leave this building. However, the distinction in the context of the Sunshine Law and public records is indistinguishable, which means that you all are in the same boat at the same time with the same legal issues that confront you on a daily basis. One publication which I think is useful just to remind those who are not in public life on a daily basis is this one here. How many people have ever seen this book before? Raise your hand. All right, this is the Bible. This document called the Government of the Sunshine Manual is published annually. This is the 38th edition this year, 2016, just for reference. I remember back in the day when the first edition was a pamphlet, literally, with citations and the statute. It has now grown to about 300+ pages. The typesetting is quite small for those who are eye impaired, and then need your glasses to actually read this thing. It reflects not just on the Sunshine Law, but also public record. It's a very useful tool. It's a document and a document which courts actually rely upon and cite to in the context of their support for what is in this particular publication. I know our local government folks here, elected local officials, get this document every year typically. It's worth acquiring. The First Amendment Foundation is the actual publisher of the document, and the preparation of which comes from the AG's office. So the combination of both is quite significant. And the laws that apply here apply elsewhere in the state of Florida and outside of just this agency itself. All right, now, I'll get to the next slide. Yes, it is. Here?
The arrow.
Sure.
I think it's the arrow.
The arrow.
The arrow.
Aha. It's a good place to start. Okay, a couple of observations. This is the short course regarding sunshine and public records. For those who have heard the word sunshine and public records for most of their natural lives working in Florida and public life, the Sunshine Law derives from the Florida Constitution. Article 1, Section 24. Not Article 24, Section 1, but Article 1, the first article of the Florida Constitution, up front and personal. And the Sunshine Amendment to the Florida Constitution includes both the Sunshine Law that affects public records and sunshine, but is also the Sunshine Law together. So in the Constitution itself, Article 1, Section 24, it's based in the Constitution. The statute which follows, Chapter 286, is the statutory reference to that particular provision. In the Constitution, which is before you here, essentially what it says is that all meetings of public bodies are public meetings unless they're exempt from the state statute specifically. And this entity, the Regional Planning Council, as either a state or a quasi-state agency, is subject to the requirements of Article 1, Section 24, and all the applicable sections of Chapter 286 of the Florida statutes. The consequence of which is the legislature, by its own authority, is exempt from many aspects of the Sunshine Law. They're allowed to meet in private and deal with public business in a closed-door fashion, which under the Constitution is actually protected and allowed for. That's not the case for local government bodies such as this one, with some exceptions. Chapter 286, very short statute, it's only about 5 or 6 pages, not a very long provision under state law. It is the guidepost which guides all of us in this room, not just any one of you sitting here, but staff, your legal counsel, and also aspects of members of the public and consultants who do business with public agencies. And I'll tell you a reason why in a few minutes. It says all meetings, not just some, but all meetings of local governmental bodies which are defined in the statute, county, municipal, and other entities of government as well, are open to the public at all times. Typically when I make this presentation, I say we're in a public building and therefore the public has right of access to the public building. Well, exception, we're not in a public building today, but there are several events occurring at the same time this morning which are compelling. One of which is a tape machine's going and everything that's being said here is being recorded for purposes of certification in the future. The doors aren't locked, and members of the public can actually physically access the building for the purposes of this discussion I'm having with you today and the business of this agency as well. The consequence of which is that all meetings at all times, except for very limited exceptions, which we'll talk about in a few minutes from now. 3 basic requirements under 286, and you'll hear this frequently among your colleagues and friends. Open to the public, so that anyone can knock on the door and come into this meeting and sit in this audience not be disruptive, but to be with you for the purposes of hearing what is occurring during today's presentation. Number two, notice must be given that this meeting is actually occurring. So the consequence of which is if we could have it in this building, make it accessible to the public, but not tell anybody. That's a problem under Chapter 286. This meeting has been publicly notified in the statewide newspaper, which occurs 21 days before the meeting actually occurs. Because as a state agency or a quasi-state agency, we're required to actually publish in a state newspaper. The consequence of which there is the fact that not just people in Hollywood, but people all over the state of Florida know that you're meeting today. Whether they're here or not, or chose to be here or not, is their business, but they have the right to see what your business is and to physically be here specifically. And the third thing is, and earlier on, Councilmember Walters made some suggested changes, as did Commissioner Suarez, to the minutes. Well, guess what? What you do and what you say matters, and what it matters most about is the fact that there are minutes kept by Karen and by Kathy that actually reflect and confirm what occurred at the prior meeting, so that John Q. Public has a right to know exactly what you did and how you did it. Consequence of which there is the fact that these three component parts of 286 matter on a daily basis as to how you do your business. What's the purpose? Couple of things. The purpose is that in Florida, it is the Sunshine Law in Florida is the most liberally construed Sunshine Act in the country. Just ask the Sun Sentinel these days, who are basically having a lot of fun with Broward Health in the context of their public business, or Memorial's healthcare system and their public business. The public has a right to know what's happening. They don't have a right to be heard at every public meeting. They have a right to know exactly how their public officials are acting as if and when they make certain decisions. The key factor being that when a decision is being made, the public has a right to know that that decision is occurring and the when part. Decisions are official action which may include three things but are not limited these days. Recommendations, which this entity does on a frequent basis. Discussions, which you have on a continuous basis. And deliberations, which you always have when you meet every month in this chamber or elsewhere. So those three component parts of purpose actually do matter. Who is subject to the Sunshine Law? All of you. All of you and me and you. We're all part of this process, good, bad, or indifferent. It exists in Florida, and it's something which is very, very important. Any public entity, essentially, whether it be a school board, a special district like Broward Health and Memorial Healthcare System, or a city such as Cooper City, or the county as in Broward County, or in Miami-Dade, or Key West. It all applies the same. The law is no different as it is here as it is down south. It's the same in Jacksonville as it is in Tallahassee. It applies to all electeds and all appointeds. You qualify in that category. In fact, several of you qualify in both categories because you are both elected and you are also appointed. It also applies to advisory boards. Advisory boards that actually make formal and physical recommendations. So a recommendation by an advisory board is also subject to the Sunshine Law as we know it. The legislature has some limitations. It is not specifically embraced in the Sunshine Law, but there are some aspects of what the court system does, which is also prescribed by and controlled by the Sunshine Law. Fact-finding committees. This is one of the exceptions, and there are very, very few. If a group is actually established to basically render facts, evaluate facts, better said to gather facts, and not make a recommendation, it is not a part of the Sunshine Law requirements. Interestingly, however, there are very, very few fact-finding committees. Some local governments, in an attempt to be useful in how they approach business, may in fact create a fact-finding committee, such as gather data with regard to salary information for people in certain categories. Not to make a recommendation about salaries, not to evaluate the salaries, or to make a decision about the salaries, but to find them. Just survey and get the data. Just an example. The consequence of which there is the fact that there are very, very few fact-finding bodies because everything we do is typically open and notorious. And lastly, private organizations. Just because you hire a private sector employee, a consultant, someone who may be sitting in this audience or someone who may be engaged to help, does not mean, for example, that they, because they're private, can render the conversation, the discussion, and the records private as well. I'm a public practitioner, but I have a private law firm. We actually have separate files within our office which are public files for public access. And we have those which are not public, which are for private clients. The consequence there is that private organizations, consultants are also prescribed by the Act. You've heard this before. I know time is getting short, forgive me. Two or more, any gathering, formal or informal, where two or more members of the same collegial body discuss an item which may foreseeably come before that body. Keywords: foreseeably appear and come before that body. where the crystallization, the case law says crystallization of ideas. So for example, if Councilmember Goldberg meets with Commissioner Furr on an item which is coming before the County Commission, that's not an issue because they're not talking about Regional Planning Council business. But if they meet to talk about an issue which may appear on next month's agenda, even though Commissioner Furr is on the County Commission and Councilmember Goldberg is a private citizen but acts in a public light, they can't discuss today's business or next month's business regarding this issue as two or more members of the same organization. Correspondingly, they can't pick up the phone, either one of them, and call Isabel and say, Isabel, Beam can't pick up the phone and say, I want you to talk to Kerry about an item coming up on the next agenda. Help me out here. I need to get his support. Would you do that for me and suggest I need his positive support for a particular vote? Okay? That's a violation of Chapter 286. You can't use Isabel as a conduit to transist information from Councilmember Goldberg to Commissioner Furr and back and forth. She can't be used for that particular purpose. Interestingly, as a government practitioner, as a city attorney representing a number of cities in South Florida and Broward County in particular, and representing an agency like this, I can know what each of you are thinking at any one particular period of time. That's why I have no hair. It's all burned off. I used to have hair, flowing hair, long hair. I'm sure Greg remembers that. Unfortunately, the result of which is the fact that I can know what each of you are thinking at any one particular period of time, but I can't not transmit what, for example, Commissioner Bass is thinking to Commissioner Cotton, even though I may know exactly what they're both thinking. And this is one of the conundra that we have as public lawyers, is the fact that we know these things. How we apply them and how we use them is a key factor in being protective of the people that I'm standing in front of this morning. Yes, ma'am.
Sam, isn't that sometimes a conflict with city managers?
Well, city managers...
I mean, they know what all of us are thinking.
They do.
And how do we know that they don't say what we said to someone else?
The law absolutely precludes the transmittal.
Because I've seen that happen.
You know that your manager cannot transmit to any one of you the same information to each of you. I can, as a city attorney, as a government practitioner in this room and elsewhere, do the same thing. It's not possible. So the temptation to resist that transmission of information becomes very compelling and very difficult sometimes. And sometimes you as public officials are highly frustrated by the fact that you know that your manager may know the answer to the question. So for example, if you're sitting on the same public body and Commissioner Furr knows what Commissioner Ryan is thinking because the lawyer or the county manager, county administrator knows the answer, they can't use that person to get to the answer. Or they can't use the conduit for the purposes of convincing another to believe something's right, wrong, or indifferent. It's a challenge that we have every day of the week. I use an expression publicly because I care for you all publicly and privately, called reading of the tea leaves. It may be something where a lawyer or a city manager can correctly and perhaps delicately deal with a subject matter that may be coming up before the commission, but the delicacy of that is, and the sensitivity of that is, you need to be very careful about that information. Because I'll tell you the reason why in a few minutes, but that's a very difficult task to get engaged in, quite frankly. Okay. By the way, there doesn't have to be a quorum. So if the mayor of Cooper City meets with another council member or commissioner, just because there are only two of them doesn't mean that they're exempt because it's not a quorum of three. Okay, and that applies in this situation as well. One-way communication, written communication. We can talk about email for the next 3 days, which is, we don't have 3 days, but I'll give you the primer on that as best we can. Oftentimes you'll see emails from Isabel or from me or from staff or from your own professional staffs which say, do not reply to all. There's a reason for that. Because online exchanges, online information, and online discovery and delivery of information can become a public meeting in no time. Where if, for example, Commissioner Weekly, Commissioner in Key West is communicating online to various other parties and has a conversation with other commissioners and begins to develop the information necessary to make decisions, it becomes challenging in the context of the public record side where the decision is being made on the record specifically through the internet, which is not legally allowed. So interaction among board members is not allowed. I suggest again that do not reply to all concept as well. Talked about third-party liaisons, which are essentially conduits, not a good thing to do. You can't use that conduit theory to implement your decisions as well. There are several exceptions, and no time is short. I'll be as quick as I can. Those exceptions relate to attorney-client shade sessions, If a governmental agency is being sued, lawsuit is pending, not a claim, a lawsuit is pending. That's what the case law tells us. A lawsuit is pending, then it is possible to go into what's called a shade meeting. If this is a sunshine meeting, we can go to a shade meeting with conditions. It has to be noticed, okay? And the attorney who wants to have a shade meeting has to ask for it. And not the day that he wants to have a shade meeting, by the way, or she. It has to be asked for now for next meeting, or for a special meeting for that purpose. Why, you ask? If the public is excluded from the shade meeting, why would you want to ask for it in public? Why? Because they have a right to know they're going to have a shade meeting. Because Florida law says that they have a right to know. They may not have a right to know the information at the shade meeting, but the right to know that there is such a shade meeting. The consequence of which there is a gas for it during the public meeting, and there is a court reporter present in the room during the course of the shade meeting. In fact, the meeting opens with a public meeting. You open the public meeting of a shade meeting in a public session, and you close the shade meeting in a public session after the shade meeting closes. You adjourn the shade meeting in public. The end result of which is that there's a court reporter in the room, and the transcript of the conversation is actually sealed until the case is resolved, otherwise to the appellate court of last jurisdiction. Those are the guidelines, essentially. And I know that many of you have been, how many of you have been through shade meetings in the past? And special counsel, by the way, are allowed in the room for that purpose as well. I remember going to a meeting in Key West some years ago on behalf of the city, a special counsel, and the councilman who's no longer on the council, commission back then, questioned why the court reporter's in the room. Said, she's not a council member, she's not special counsel, why is she here? Well, the end result is the statute actually contemplates having a court reporter who is legally authorized to be in the room. Although we raised the issue with me as to how that could happen. Otherwise, you can't have anything off the record either in the context of the presentation. God bless you. Executive sessions. We don't have the issue here with labor, but under Chapter 447 of the Federal Statutes, when you do with labor negotiations, executive sessions are even a hybrid beyond just a shade meeting. Executive sessions relate to collective bargaining under Chapter 447 of the Florida Statutes. There is no record of the meeting ever occurring. How many have ever been in a collective bargaining meeting? We all have, okay? The end result of which is that nothing that is taken into the room comes out of the room. Okay? You post notice, some do, some don't. Post notice of the meeting specifically, but the conversations that are occurring in that room are limited to the public officials in the elected body, their city manager, county manager, executive director, and the lawyer. And essentially, there's nothing which leaves the room. It's all privileged and protected, and there's no record, there's no tape-recorded meeting, and there's no record with regard to a transcript as well. In fact, we have told our public clients that to transist information from a collective bargaining session to third parties could also be criminal. Why, you ask? Because you compromise the rights of your negotiator to negotiate in good faith when you have the opportunity to know information that's otherwise privileged and breached if it's allowed to leave a collective bargaining session, executive session. Yes, sir.
Is that the same for a shade meeting?
No.
For what?
Shade meeting.
No, shade meeting, you shouldn't be talking about things outside the room either, but there's a record of what was discussed, which is the transcript itself, which is sealed until it's otherwise legally available because of settlement. But be mindful and be careful. The third thing is under state law now, under procurement selection committees, before you actually finalize an RFP or a bid, they're also privileged and confidential. One more exception, which I didn't mention, it's not on the list here, but the security of public buildings post 9/11, you can actually have a closed-door session with your public official to talk about plans and specifications like your annual water plan. If you're want to tell terrorists about where the button is to push to turn the water plant off, then you have a public meeting to discuss where the button is. But in the context of the statute, you are allowed, not under this statute, by the way, in 286, there's an ability to actually have a closed-door session talk about the security of public buildings, so that you can actually look at building plans and be secure in knowing that the public information will not be transisted from there. Okay, you're all part of it. Just side note, candidates, by the way, if you become a candidate for public office, you're also subject to the Sunshine Law, as a matter of fact. And to the extent that you're elected as a commissioner-elect or a council member-elect, you're not allowed to have conversations with your colleagues who are your future colleagues because of the issue of sunshine as well. Does not apply to candidates unless they actually are elected, just for reference.
Sam, question. The issue of socialization between members, I really like Jimmy Weekly, and I like to go to Key West, and he says, come down and spend the weekend. Are you going to do that, aren't you, Jimmy? And we just hang out, you know? What do we have to know about that?
Well, you have to know a couple of very important things. That usually the best answer is that when you're dealing with a colleague on the same board, you can talk about family, baseball, and the weather. Those are three very safe topics. You don't have to worry about those three topics. It's when you begin talking about issues that relate to the future business that matter. I'll give you an example. In a city we represent to the north of here, there were several public officials, elected officials on a boat that were with a code enforcement director, and they were cruising through the canals. They were taking pictures, and they were looking at various sites in that particular city referencing code violations. Turns out that at the end of the day, someone who saw them doing this suggested or thought that because two or more of the same council were in that boat on the same day, they were reported to the state attorney's office for alleged sunshine violations on the presumption that their very presence on the boat looking at theoretical code violations was a violation of the statute. The end result there was that the case was opened, but no cases ever filed, because matters could be discussed and were otherwise cleared. But it's a very sensitive subject which you raise. For example, League of Cities events, League of County events, FRICA events, matters where you may come in contact with your colleagues, not just here but elsewhere, are typically those events which are open and notorious, where one can think it's not a bad place to be and you can have a conversation. Unfortunately, when you take the oath of office as an elected public official, and you become a member of this council and you accept the responsibilities of it, you take on a whole new aura for yourself. Because as I tell people, you're a public official 24/7. You don't just shed yourself of that issue and go to Publix or Walgreens and believe that you're no longer susceptible to the requirements that are provided for in the statute. It's a 24/7 obligation. And unfortunately, I can't know who's watching you at any one particular time. Not that I'm suggesting paranoia, by the way, but you don't know this. Because what I can tell you is that in my experience, investigators from various other governmental agencies find their way to where you are, because that's what they do. And they will access in a very reasonable and cautious fashion, whether it be a bar or a restaurant or Publix, where you might be otherwise accessible, where in fact sunshine law violations might occur.
Sam, could I ask about political action committees?
Yes.
That's making a recommendation to the public, but not to an elected body.
Correct. If they're not specifically provided for in the statute, and I've not had that question asked in a while, but my best answer is that PACs are typically not public entities. They're created by state law under Chapter 106, where they actually have to form them and file with them and have them created, but typically they're not prescribed by the same statutes as far as I know. Have you had occasion to deal with them in the past?
Yeah, just recently, actually,
Yeah.
where the city had passed, the city commission had already voted, and the question was going on referendum to the citizens. And there was a political action committee that was formed to promote the passage of the referendum. And as an elected official, I happen to be on the political action committee in support of it. And I was asked to speak at different events and that type of thing.
As you begin to evolve the facts, the PAC could well become
Just
public
putting the
very
facts
quickly.
out. I mean,
Yes.
the commission already voted on it.
Yes.
There's not going to be another vote by the commission. And so it was just on the referendum question.
One caveat, which is to always rely upon the advice of your local government attorney under Chapter 112, whether that be me or your city attorney, whoever, maybe county attorney. It's always very important to seek that advice, because as you'll see very quickly in the slideshow that I'm going to try to close on very shortly, if you rely upon the advice of counsel, you are protected. There's a protection under 286 if you rely upon the advice of counsel. If you say you relied upon the advice of counsel, that's one thing. You also give your lawyer the full set of facts as well, much like getting a safe harbor opinion from under the ethics code in Broward County, which requires that you give a full panoply of facts before you get an answer. You raise a good point. The monies that are put into the organization may not be the only, because they're private dollars into the PACs. They're not public money. It's not allowed to use public money for that purpose to advocate. But at the end of the day, it opens up a door, I think. As the facts get more intensive, I'd be more concerned about it being public in some fashion. Violations of the Sunshine Law are not trivial. They are criminal, potentially. It relates to the potential for suspension or removal. It can affect your pension. It doesn't look really good on your record, and affects your reputation on a permanent basis. W.B. Childers, you may have heard of him. He was the former president of the Senate in Florida back in the day. He helped write the Sunshine Law back in the day. He evolved out of the legislature, became a county commissioner in Escambia County. He was one of the first public officials to be prosecuted under the Sunshine Law for violations. One of his own colleagues actually blew him in, just for reference.
I don't want to be there.
Yes.
ever.
He also went to jail, I must suggest. Although 38 days is not terribly bad, I wouldn't want to spend one day in jail. He spent 38 days and paid a fine, and also was affected by this on a permanent basis. It does happen. God forbid it should ever happen to any one of you. Because of the shortness of time, I'm going to defer the public records part to the next time. The
Right, I
Sunshine
think
Law
so,
is-
if you don't mind saying.
No, I'm going to do that. I think it's valuable to do that. I would encourage you to be thoughtful. My presentation, although quick and rapid, as the case may be, and you've heard much of this before, it's just to remind you the fact that when you leave this room today, as good as you all look, as good as you've been to listen to my presentation, all I can do is give them my best advice, which is to be thoughtful, be mindful, be conscientious, and be aware of the fact that these laws are serious items. You read about them in the newspaper. I'll close with this. I happened to be looking this morning in the list of members of the First Amendment Foundation, and one of the members of the foundation we all know, and she is, can't go far. She's the editor with the Sun Sentinel. She's writing all the stories right now about sunshine. It's Rosemary O'Hara, who is with the editorial page editor for the Sun Sentinel, who has been vicious, I use that word, well, creatively aggressive about violations or alleged violations of the Sunshine Law for Broward Health, as a matter of fact. And she's a member of the First Amendment Foundation. And these things happen on a daily basis. As your lawyer and as the one sitting in that seat, I recognize these kinds of implications. They're serious business. Rely upon the advice of counsel. Be mindful, be thoughtful, and don't be looking over your shoulder because it may be getting closer, as Satchel Paige once said, but they're right behind you. Okay? Thank you all very much.
Nobody does it better than Sam